Hello, this is Attorney Brian Pendergraft with the Pendergraft firm, and the topic for today's video is, can a tenant or landlord revoke or rescind a notice to vacate in Maryland? As a general rule, the answer is no, because it would be unfair to allow a landlord or a tenant to revoke or rescind a notice without the consent of the other party. The reason being is because once one party gives the other party notice, then they make anticipatory efforts in anticipation of the other party upholding their end of the bargain. So it would be unfair to both the landlord and the tenant. And to illustrate what I mean, first I'll explain why it's unfair to tenants for landlords to be allowed to rescind their notices, and then I'll explain the other way around. Here is why it is unfair to allow a landlord to be able to rescind or revoke a notice to vacate in Maryland. So what if a landlord sent a tenant a 60-day notice to vacate, but then decided to rescind it or revoke it on day 53 because they decided that they changed their mind and want to continue with the lease? By then, the tenant has already entered into a new lease and has paid money to move and store their belongings. It would be unfair if a landlord could just revoke the notice to vacate and to put the tenant in position where they have to pay for two leases. For that reason, it's unfair to allow landlords to be able to rescind a notice to vacate. Now I'll explain why tenants can't rescind or revoke a notice to vacate in Maryland. In the same manner, if a tenant gave a landlord a notice to terminate, then the landlord would have to spend efforts to market and relet the property. Landlords often enter into contracts with new tenants that begin shortly after the current tenant's lease expires. And if the old tenant does not leave, then the new tenants will essentially be cheated out of a living space that they legally contracted for. And the new tenants may be able to sue the landlord for this. For that reason, it's unfair to allow tenants to revoke or rescind a notice to vacate. Before I conclude, I'd like to make a few caveats. The first caveat is more common sense than a caveat. So if the other party accepts the rescission of the notice, then that notice is most likely effective. This is because parties can agree to modifications. That said, if they are to do this, they should probably do it in writing, because real estate contracts tend to need to be in writing per the statute of frauds. Now, the second caveat is that if the lease agreement stipulates that conditions of which a party may rescind a notice to vacate. Now, a clause like that may be found in a commercial lease agreement. I've never seen one in a residential lease. Now, notwithstanding these caveats, tenants and landlords are not allowed to rescind or revoke a notice to vacate, because it would be unfair to the other party. Thanks for watching. Again, I'm Brian Pendergraft with the Pendergraft firm, and the information on the screen is how to reach out to me and schedule a consult. Alrighty, thanks for watching. It's also in the descriptions as well, so you'll be able to click a link and go from there. Alrighty, thanks for watching.